Welcome to another exciting episode of Unraveling Intellectual Property with Michael Stein. Today, I am pleased and honored to have Jonathan Stroud, who is the Chief Operating Officer and Chief Legal Officer of Unified Patents. He is also an adjunct professor at the George Washington University, and he's also a fellow AU Law alum. Uh, uh, Jonathan, welcome.
Thanks for having me. Happy to be here.
So, why don't you tell us? I mean, I know Unified's an industry leader. Uh, I'll let you say and tell the audience what you guys do and what you do in particular.
Sure. So Unified has been around for about going on 13 or 14 years now. Unified is a defensive membership organization. So other companies are members of Unified, sort of similar to RPX. Um, we we basically do everything we possibly can as a third-party company to deter what we see as frivolous or non-practicing entity litigation that never should have been brought. I'm a former examiner, and my boss is a former examiner, and my grant rate was something in the range of 28 to 29%. I think my boss's was higher, but you obviously know when you're in your 20s and you're granting patents that you make mistakes. The office makes mistakes, right?
Mhm.
And those mistakes can be leveraged based on the high cost of litigation against lots of defendants. They often are. Defendants are sometimes sued in bunches or bulks. Occasionally over 100 defendants will be sued. So our members pay us, and then we will go to work every year. We try to deter what we see as like invalid patents being asserted for less than the cost of litigation, is the summary.
I'm guessing that you evaluate some things and say, no, there might be a good case. I mean, clearly you're not going to tell people, but
Sure.
you just don't go nilly-willy and go on the attack without some pretty strong basis to do so.
That's absolutely right. One of the nice things about being an independent third party is that we're making our own decisions. And so we look at cases all the time that have patents that are clearly very strong, right? There are portfolios out there that are heavily licensed and monetized that originated in the hands of operating companies, maybe are still now in the hands of non-practicing entities, but there's a back end or what have you. But the patents themselves are incredibly strong, right? And we do our own independent analysis. We challenge patents that we have a cultural basis that we think are invalid, right? And we have a very good track record because of that. I think there are a fair number of issued patents out there that suffer from some validity problems somewhere in the claims. And it's important for there to be someone out there in the free market checking that and making sure that patents are kept within their appropriate scope. And that's something that we've been doing since day one. I've been here for about 11 and a half years, and have really enjoyed the work. Yeah,
And so your members, they've got no say in how you spend their money. Is that accurate? I mean, are
that's
they
right.
winking and saying, why don't you take a look at this, or
Hmm.
sending you a secret text on your home phone, or like how do you make decisions on, I mean, there's tons of litigation. Like how do
Sure.
you decide where to
Well, the latter point is probably the better one to start with, which is that it is a target-rich environment. There are over 4,000, 3 or 4,000 patent suits brought a year. Some estimates put that at 8 or 9,000 unique patents asserted every year. That's just the ones that are asserted. That's not the iceberg under the water of all of the
right.
demand letter and all the other portfolios out there. So there are a lot of, I think we're up to 13 or 14 million series, but even in the US, there are at least 3 to 4 million active US patents. If you were to give an organization infinite money to try to challenge every single patent that was part of litigation, it would cost so much money that it would make no sense at all. I mean, we file about 60 to 80 targeted challenges a year. They're not all the subject of litigation. A lot of times they are subject to part of a portfolio or something where it seems like they're not within their legitimate scope, or they're holding up AI companies from innovating, or they're trying to assert patents against the blockchain or something like that. We make our own independent calls about how we spend our money, and obviously have limited resources and need to triage. But generally, we try to challenge patents that we have a strong validity case on, that are widely asserted in the hands of non-practicing entities, and that are seemingly being used to leverage the high cost of litigation rather than um, being based in sort of a concrete business dispute between two entities with a clear damages theory and strong validity, right? So it's a judgment call at the end of the day, just like it is for anyone. But we're not a litigation solution. We're not handling privileged work, right? What we do is not privileged. And so, because of that, we built up this track record as an independent third party that does everything they possibly can to deter bad actors.
Are are pretty much all your challenges against non-practicing entities? Do you also challenge patents of practicing entities?
Almost all, if not all, of our patents challenges have been against non-practicing entities. There have been some in standard essential patent areas that have been brought against holding companies or companies that are net licensors, that more than 50% of their annual revenue is based on patent licensing, right? In our opinion, companies like that, especially in the standard essential space, may be overrepresenting what patents are essential or what patents are part of certain standards or pools, particularly when they didn't participate in the standards process themselves. And so the goals of the standard essential patent zones are a little bit different, but they're effectively the same, which is to say there is litigation out there that is, if not frivolous, then probably transaction costs that are not tied to the actual value of the underlying innovation, and there should be a third-party entity out there doing what they can to help the office sort of clip the portfolios and make sure that they are within their appropriate scope.
So
But to,
are
go
you
ahead.
literally looking at like every single lawsuit and or those of non-practicing entities and doing at least some quick preliminary analysis or
Yeah, not me personally, because there
no,
are
I
so
think
many of them that it takes quite a bit of time. Although we were attempting to do that early. We do have demand letter information and secondary market information and assignment record information as well. Like I said, there are thousands filed every year, and it can be quite a lot to bite off. But we have a good indicator value based on the use that entities have, right? If they're
okay.
going to use the patent or send letters or assert or list them publicly anywhere, and if they're going to transfer them to a hedge fund or a litigation funder or a third party LLC, you get a good sense that it's going to be asserted, and that the goal is to sort of leverage the high cost of litigation to drive licensing. And that's where the rubber meets the road, because it is totally fair and it makes sense. That's how the business of licensing gets done. But it shouldn't get done on patents that the office never should have issued. And obviously, there have been a lot of studies over the years that have demonstrated that just a fair amount of patents in the I would argue sort of tilted process of patent application that sort of assumes that a prima facie case needs to be made sort of in favor of the patent owner. You have young examiners, you have a high volume with low time. Mistakes are made all the time. And so we're here to facilitate on the back end to help people re-look at those patents and make sure that everything is held within its legitimate scope.
All right. So there's been a lot of changes, and I know we're going to
Sure.
we're going to go into part two because but there's been a lot of changes at the USPTO.
Mhm.
The new commissioner Squires has made significant changes in the IPR process and what they call it, implementation or acceptance. What's the word I'm looking for? When when the USPTO accepts
Institution. Yeah.
institution. I knew I couldn't think of it.
Mhm.
But so why don't you let's get into first what are the changes, and then in part two, let's talk about strategies that Unified and others are doing to adapt to those changes.
Sure. So, my father used to say that the dirtiest word that could be used to describe legislation in the United States is effective. And so when someone passes a bill or puts a new procedure in place and it is effective at disrupting business, it will get a lot of attention. And I think you can look at the AIA and what happened over the last 15 years as sort of Exhibit A. There had been, I think, 9 Supreme Court challenges, at least 6 of which were taken up over the last 15 years on aspects of the AIA. There's been a fair amount of very vociferous lobbying about the AIA because IPRs and PGRs to some extent were very effective at providing a parallel track, an alternative track that would stay litigation and would result in cancellation of some claims. And it dramatically impacted the business of patent law. So for the first 7 years of Unified's existence, the primary tool that Unified used was IPRs, inter partes reviews. They were a streamlined form of inter partes re-exam. They were not without controversy, and they were making changes all along the way, of course, because it was a new regulation. But Unified also started with the very first challenge being a re-examination and had been filing re-examinations all along the way. Starting as far back as 2019, 2018, I think pre-pandemic, we were filing about half of all of our cases as re-examinations. Um, as things got clearer, it became clear to us that people were not using ex parte re-examinations because of the availability of IPR, but that they were actually quite effective. It was not your sort of grandparents or parents' ex parte re-exam. I remember doing them at the firm, and they would be 10,000 pages long and take forever and didn't make a lot of sense. And there would be amendments, and there would be sort of confusing answers. But the CRU in the interim professionalized and got their pendency down and did things differently and learned from the board. And so they actually turned out to be quite an effective tool. So 4 years ago or so, maybe 3.5 years ago, Unified made the independent business decision to switch entirely to re-examinations as our primary tool. We do file protests and
Because I mean, I maybe
yeah.
some of the masses, I don't know how closely people follow Unified. I kind of thought you were doing mostly IPRs.
Yeah, I know. I was always a big fan of using whatever tools we had in our tool chest. So we even filed supplementary examinations and some pre-order submissions, pre-issuance submissions. We filed in Europe and in Asia. We filed oppositions. We filed Chinese oppositions, EP oppositions. I think we
How's your
filed in
Chinese?
Japan. My Chinese is not very good, but local counsel is very good at what they do. I will say that the Chinese opposition procedures were a fascinating learning curve in terms of what we've come to expect in the United States as due process is something that is a newer acquisition for them. And so there's a lot more flexibility in terms of timing and the arguments that can be made. And they don't have the same rules of stare decisis and other things that we have here. They don't have the same administrative prohibitions against like ex parte communications with the board or what have you. It was an interesting experience, but
All right, let's
yeah,
take a break. Sorry to interrupt you.
yeah, sure,
You're in the
no
middle of
worries.
that thought, but we're going to get back into what Unified Patents has been doing,
Sure.
and uh, we're going to get Jonathan Stroud back. To my audience, thank you for tuning in. We're going to get Jonathan right back for part two.